This is Randy Barnett, the Carmack Waterhouse Professor of Legal Theory at the highly regarded Georgetown University Law Center, where he teaches constitutional law and contracts. Professor Barnett previously served as prosecutor in Cook County from Calumet City, and he been a visiting professor at Northwestern and Harvard Law School. Of particular relevance for today's hearing, Professor Barnett argued the Commerce Clause case Gonzalez versus Raich, which we've heard referred to several times, before the Supreme Court in 2004. Graduate of Northwestern University and Harvard Law School. Thanks for coming today, and please proceed with your statement.
Thank you, Senator. In 2010, something happened in this country that has never happened before. Congress required that every person enter into a contractual relationship with a private company. Now, it's not as though the federal government never requires you to do anything. You must register for the military and serve if called. You must submit a tax form, fill out a census form, and serve on a jury. But the existence of and nature of these few duties illuminates the truly extraordinary and objectionable nature of the individual insurance mandate. Each of these duties is inherent in being a citizen of the United States. Each is necessary for the operation of the government itself, and each has traditionally been recognized. In the United States, sovereignty rests with the people, with the citizenry. And if Congress can mandate that you do anything that is convenient to its regulation of the national economy, then that relationship is now reversed. Congress would have all the discretionary power of a king, and the American people would be reduced to its subjects. In essence, the mandate's defenders claim that because Congress has the power to draft you into the military, it has the power to make you do anything less than that, including mandating that you send your money to a private company and do business with it for the rest of your life. This simply does not follow. The greater power does not include the lesser. No one claims that the individual mandate is justified by the original meaning of the Commerce Clause or the Necessary and Proper Clause. Instead, the government and those law professors who support the mandate rest their arguments exclusively on Supreme Court decisions. But given that economic mandates have never before been imposed on the American people by Congress, there cannot possibly be any Supreme Court case expressly upholding such a power. In my written testimony in a forthcoming article, I explain why nothing in current Supreme Court doctrine on the tax power, the Commerce Clause, or the Necessary and Proper Clause justifies the individual insurance mandate. To summarize that, rather than impose a tax on the American people, Congress decided instead to invoke its regulatory powers under the Commerce Clause. But because the commerce power has never been construed to include the power to mandate that persons must engage in economic activity in litigation, the government has been forced to rely heavily on the Necessary and Proper Clause. But the individual mandate is neither necessary nor proper. First, it exceeds the limits currently placed on the exercise of the Necessary and Proper Clause provided by the Supreme Court in the Lopez, Morrison, and Raich decisions. Second, the individual mandate is not necessary to, quote, carry into execution, unquote, the regulations being imposed on the insurance companies. Instead, it is being imposed to ameliorate the free rider effects created by the Act itself. Congress cannot bootstrap its powers this way. In my written testimony, I also explain why the individual mandate is improper because it commandeers the people in violation of the 10th Amendment that reserves all powers not delegated to to Congress by the Constitution, quote, to the states respectively or to the people. The 10th Amendment protects popular sovereignty as well as the states. But wholly apart from what the Supreme Court has said about Congress's power, each senator and representative takes his or her own oath to uphold the Constitution, and each must reach his or her own judgment about the scope of congressional powers. After the Supreme Court relied on the Necessary and Proper Clause to uphold the constitutionality of the Second National Bank in McCulloch versus Maryland, a case you're going to hear a lot about today, President Andrew Jackson vetoed the renewal of the bank because he viewed the bank as both unnecessary and improper, and therefore he found it to be unconstitutional. He wrote, quote, if our power over means is so absolute that the Supreme Court will not call in question the constitutionality of an act of Congress, the subject of which, and then he quotes McCulloch, is not prohibited and is really calculated to affect any of the objects entrusted to government, it becomes us to proceed in our legislation with the utmost caution, unquote. Therefore, regardless of how the Supreme Court may eventually rule, each of you must decide for yourself whether the mandate is truly necessary to provide, for example, for the portability of insurance if one changes jobs or moves to another state. Each of you must decide if commandeering that Americans enter into contractual relations with a private company for the rest of their lives is a proper exercise of the commerce power. If you conclude that the mandate is either unnecessary or improper, then, like President Jackson, you are obligated to conclude that it is unconstitutional and to support its repeal. But even if you do not find that the mandate is unconstitutional, this week's ruling in Florida suggests that there is a good chance that the Supreme Court will. So you might want to consider constitutional alternatives to the individual mandate sooner rather than later. Thank you.
Thank you very much, Professor Barnett.